Hello and welcome to everyone joining us today. My name is Elizabeth Moore and I'm the news team lead here at Ballotpedia. We're really so happy to have all of you with us as we discuss the fascinating topic of the current Supreme Court term. Here to help me dive into all of this today is elections team staff writer Kate Carcella. Hi, Kate.
Hey there, Elizabeth. Welcome to Scotus land.
Thank you, and thanks for being here with us. This has certainly been a trailblazing term for the Supreme Court, hasn't it?
Absolutely. First, if I may, I would like to address some newness related to Ballotpedia's SCOTUS team and pay brief homage to our Chief Justice Emeritus, Sarah Reynolds, who has voyaged from BP onto some new adventures. Thank you, Sarah, for your service to our court's coverage.
Yes, we will definitely miss Sarah and all her work covering this area for Ballotpedia. The Supreme Court also had a big transition in membership this year. Let's start there.
Yes, indeed. So Associate Justice Ruth Bader Ginsburg's service with the court ended on September 18th, 2020 upon her death. She was first appointed to the court by President Bill Clinton and joined the court on August 10th of 1993. On September 29th of 2020, President Donald Trump nominated Amy Coney Barrett to the court to fill that vacancy. She was confirmed by the US Senate on October 26th, 27 days after her initial nomination. Prior to that nomination to the Supreme Court, Barrett was a judge with the US Court of Appeals for the Seventh Circuit, which is based in Chicago, Illinois. Barrett was nominated to that judgeship by President Trump on May 8th, 2017, and joined the court later that year on November 2nd.
Thanks for that summary. Has Justice Barrett authored any opinions since joining the court?
Yes, she has. Justice Barrett delivered her first majority opinion on March 4th of this year in the case U.S. Fish and Wildlife Service v. Sierra Club. She's written two majority opinions for the court to date. The second and most recent opinion was in Florida v. Georgia, which was decided on April 1st, and that came to the court under its original jurisdiction.
Original jurisdiction means that the case wasn't appealed from a lower court, correct?
Yep, that's right. This case concerned a dispute between the states, Florida and Georgia. So the Supreme Court is authorized to hear the case for the first time. Incidentally, the court heard this case twice, once in 2018 and then again this term.
What was it about?
So this case concerned equitable water use between Florida and Georgia. Florida said that Georgia's consumption in a shared area of water wasn't equitable. Very long story short, SCOTUS has now ruled that Florida did not meet the standard of proof required to show that Georgia's use was inequitable, and the court dismissed the case, while emphasizing that Georgia is required to observe reasonable use of the water.
Very interesting. What other noteworthy cases or events have occurred lately with the court?
Well, this was interesting. So this past February, the House Judiciary Committee held a first of its kind hearing on the Supreme Court's so-called shadow docket.
Wait, what's that?
I know it sounds really, really mysterious, doesn't it? So typically when a party appeals to the Supreme Court for review of a lower court's decision or review in the case, and then SCOTUS agrees to that review, the court accepts the case to its merits docket. So that just means that the case is going to be argued, and then the court will issue a ruling based on its interpretation of the facts and also the questions that were presented during the arguments, AKA what was presented on the merits.
I'm guessing that the shadow docket then functions differently.
You got it. The term shadow docket is another way of describing the court's orders list and decisions or rulings that it issues related to emergency appeals. So these cases are not necessarily argued before SCOTUS.
So why would someone file an emergency appeal?
Great question. An example from this term of an emergency appeal would be, there have been several instances where the emergency appeal relates to a capital case and the appellant is asking SCOTUS to issue a time-sensitive ruling to halt or put a hold on a death penalty sentence.
I see. So what was the House committee hearing about?
Well, among other things, the Judiciary Committee wanted to learn more about what the so-called shadow docket is, i.e., how and why parties file emergency appeals with SCOTUS, how and why the court is making its decisions in these appeals, Also, how these rulings impact the authority of lower courts, particularly when the lower court's judgments are reversed or vacated.
How else do these rulings differ from merit docket rulings?
In a few ways. Oftentimes, these rulings are unsigned and are a few lines long, and they don't offer legal analysis in support of the decision. Also, the vote counts indicating how the justices voted aren't always included.
That's very curious. So if there are any developments on this, we can check Ballotpedia's SCOTUS coverage for updates, right?
Absolutely.
Great. Another noteworthy topic. What has been the court's response to COVID this term?
Yes, COVID is quite the noteworthy topic as per usual. The court has been hearing cases remotely via teleconference and providing live streams of arguments to the public for all of its sittings. In fact, no argument session has been held in person this term. But the court did hold its first in-person conference on March 19th of this year, though some of the justices attended remotely. And on March 5th, the court's public information office reported that all 9 justices had been vaccinated against COVID-19. We do track these updates on our term overview page and in our news coverage of the term.
Speaking of this term, shall we dive right in with more specifics?
Sure, let's put our goggles on.
Okay, so when did the term start?
Term starts on the first Monday of October, I believe. So that was on October 5th, 2020. As of this writing, the court has scheduled its final argument session for the term in May. The court will hear argument in one case, Terry v. United States. That case was originally scheduled for the April sitting, but was postponed by SCOTUS following the Biden administration's change in position in the case. That case was originally accepted during the Trump administration.
Do we know when the term will conclude?
Well, there are no hard and fast rules. Typically, terms end in June, but last term, the court issued its final ruling on July 14th. Some of the court's activity was delayed last term due to COVID. As for when this term may end, us court watchers think it could run into July, but we'll just have to wait and see.
Gotcha. How many cases did the court accept for this term?
SCOTUS granted review in 63 cases this term, though 4 cases were removed from the argument calendar.
Why would cases be removed from the calendar?
These cases involved federal policies enacted by the Trump administration, and now that the Biden administration is in the White House, some of those policies have changed, altering the government's position in the cases.
Okay, gotcha. So where are the cases coming from then?
Great question. As you can see from our lovely visual here, most of the cases on the docket this term originated from the U.S. Court of Appeals for the Ninth Circuit, and the fewest came from the First and Seventh Circuits and the Court of Appeals for the Armed Forces.
And I think we have a map showing the circuit court's jurisdiction, yes?
Yes, voila. We've also started to include SCOTUS case data on the lower court pages on Ballotpedia for handy reference, as you can see in this example. Perfect.
That's great. Yeah, now the April argument session is coming up soon, right?
Yes, that's right. The April sitting is scheduled to begin on the 19th and conclude on the 28th. The court will hear 7 cases for 6 hours of oral argument in both of the weeks. So that's 12 hours of argument in 14 cases total.
What types of cases will the court hear in April?
Well, to start from the top, I guess, the first on the docket for April is a pair of consolidated cases. Yellen v. Confederated Tribes of the Chehalis Reservation, consolidated with Alaska Native Village Corporation Association v. Confederated Tribes of the Chehalis Reservation. Just a note that this case was originally named Minuchin v. Confederated Tribes. It became Yellen v. Confederated Tribes of the Chehalis Reservation when Janet Yellen became Secretary of the Treasury. So these cases concern Alaska Native corporations, ANCs, and whether they qualify for CARES Act payments. So that's coronavirus aid, relief, and economic security payments. In brief, the tribes claimed that the ANCs should not qualify for these payments, and the Department of the Treasury agreed. But because Congress expressly included these corporations as qualifying entities under the law, the Treasury decided that it had to proceed accordingly and follow that law. The federal district court in the case ruled in favor of the government's point of view, but then on appeal, the Court of Appeals for the DC Circuit ruled that ANCs should not qualify.
Wow, that's really fascinating. What else does SCOTUS have on the docket?
Well, let's see. There are a few cases concerning Title 18 and the court's ruling in Rahafe v. United States from the 2018 term. There are a few immigration law cases, a case concerning patent infringement, a case involving Comprehensive Environmental Response Compensation and Liability Act claims, also known as CERCLA, and whether Guam or the US Navy is financially responsible for the environmental hazards arising from a public landfill that they have both owned. There's a case concerning the Clean Air Act, a case related to Snapchat stories and students' off-campus speech, a case about eminent domain under the Natural Gas Act, and one case concerns governmental disclosure requirements for charitable organizations' donor lists.
Wow, that really runs the gamut.
You said it, and that is just one sitting.
Any other cases that have caught your attention this term?
Always, yes, and certainly this term, but I will try to limit it to a few cases argued during the March sitting. So the first one I'll mention is Goldman Sachs Group v. Arkansas Teacher Retirement System. This is a class action lawsuit pertaining to securities fraud. The case was argued before SCOTUS on March 29th of this year and originated from the Second Circuit. In brief, Goldman Sachs, which is a multinational investment banking firm, made public statements about its business practices. A group of Goldman shareholders alleged that the statements were false, alleging that Goldman was publicly marketing risky financial products as ordinary asset-backed securities, while internally allowing a hedge fund client access to create the products, and then both Goldman and that client bet against the products. So that means that they would profit off of the transaction performing poorly or even failing. Meanwhile, the shareholders experienced financial losses on the transactions. Goldman disclosed its conflicts of interest the following year. The shareholders filed a class action complaint against Goldman. A federal district court certified the class. Goldman appealed to the Second Circuit, which upheld the district court, and then Goldman came to SCOTUS, and that's where we are now. Do you think we have time for me to mention one more case?
Yes, go for it.
Okay, great. Well, this one is timely because March Madness just ended. There's NCAA v. Alston, which was consolidated with American Athletic Conference v. Alston for 1 hour of oral argument on March 31st. These cases came from the Ninth Circuit and concerned federal antitrust law and the NCAA's compensation rules. In 2014, a class of Division I or D1 student athletes filed several antitrust complaints against the NCAA and 11 other D1 athletic conferences in US District Court. They challenged the NCAA's compensation rules for student athletes. These rules allow the NCAA to use the names, images, and likenesses of the student athletes while prohibiting the student athletes from being compensated for that use. The NCAA claimed that the challenge was settled in a previous case and should not come back. The Northern District of California, the court, ruled that the NCAA had to make its compensation rules less restrictive for student athletes and also concluded that these rules were unlawful restraints of trade under the Sherman Act. On appeal, the Ninth Circuit upheld that judgment, and then the NCAA appealed to the Supreme Court.
Thanks for that summary. Yeah, all of this is really fascinating. Moving on to maybe some hard numbers here. How many cases has the court decided so far?
The court has issued 26 opinions to date, and 5 were in cases not argued before the court.
When was their most recent ruling released?
This past Monday, the court ruled in the case Google v. Oracle America, a case concerning copyright infringement and fair use of computer programming code. Justice Stephen Breyer authored the majority opinion, and Justice Clarence Thomas filed a dissent. He was joined by Justice Samuel Alito. The vote was a 6-2 majority. Justice Amy Coney Barrett took no part in the consideration or decision of the case because she was not a member of the court when the case was argued. With that decision, all the cases that were argued during the October sitting have now been decided. So if I could, I do have some term data to offer you by the numbers.
Yes, that would be great.
Okay, perfect. So to date, there have been 12 unanimous opinions, 2 5-4 rulings, 5 8-1 or 7-1 rulings, including Chief Justice Roberts' first lone dissent since joining the court in 2005. A lone dissent is just like it sounds when one justice dissents from the majority opinion of the court.
Really? Which case was that?
Uh, well, Chief Justice Roberts was the lone dissenter in the case Luzabunum v. Krashevsky. The case originated from the 11th Circuit and concerned nominal damages claims, or claims where a court awards a small, i.e. nominal, monetary amount of relief to try to settle the case. The court reversed the 11th Circuit's judgment and remanded the case for further proceedings, holding that a plaintiff may continue a lawsuit if they've asked for an award of nominal damages. The Chief Justice dissented, and he concluded that a nominal damages claim is not enough to allow standing in a suit.
Who wrote the majority opinion in that case?
That was Justice Clarence Thomas. He delivered the majority opinion, and Justice Brett Kavanaugh filed a concurrence, meaning that he agreed with the court's decision ultimately, but he had a slightly different route or interpretation of the law in order to get to that decision.
How have the opinion authorships shaken out so far this term?
Well, so far, Justices Clarence Thomas and Sonia Sotomayor have authored the most majority opinions. They each authored 3. Justices Stephen Breyer, Elena Kagan, and Neil Gorsuch have authored the fewest. They each have written 1. Justice Breyer has written the most dissenting opinions so far this term with 5. The court has released 8 per curiam opinions. Per curiam opinions are when the opinion is not signed and it's delivered by the court as a whole. But that does not necessarily mean that the votes in these cases are unanimous. As you can see, I think we have a term data table where we kind of break out those decisions and the votes there.
When do we expect the next batch of opinions to be released then?
Let's see, we've had an opinion day, 1 per week for the past 3 weeks. So very well might see more within the next week or so. But either way, we monitor the court's calendar for any and all opinion updates.
I know it's too early for end of term analysis on reversal rates and term activity for the current term, right?
Yes, stay tuned for that this summer.
Okay, great. To tide us over until then, what do we have on the most recent complete term, which was the 2019 to 2020 term?
Well, right now, we do know that between 2007 and 2019, Scotus released opinions in 993 cases. They averaged 76 cases a year. Of those, it reversed a lower court decision 696 times. So that's 70.1% of the time, while affirming, pardon me, affirming or upholding a lower court decision 289 times, or 29%.
How about circuit data?
During that span of time, SCOTUS decided more cases originating from the Ninth Circuit than from any other circuit, 191 cases. The next most was the Second Circuit, which had 73 decisions.
Which lower courts had the highest number of judgments overturned in that time?
Well, the Ninth Circuit had the highest number of rulings overturned at 149, but the Sixth Circuit had the highest percentage of judgments overturned, which is 79.7%, or 55 out of 69 cases.
Alrighty, now from going back in time, do you think we could hop forward in time and sneak a peek at what's on the docket for the next term?
I suppose. Twisting my arm. No, I love talking about it. So the next term, the 2021-2022 term, is scheduled to begin on October 4th. To date, the court has accepted 10 cases, including Brown v. Davenport. That case concerns habeas corpus claims, and they just granted that one on Monday. The case originated, just to quickly talk about it, the case originated from the Court of Appeals for the Sixth Circuit. And as you can see from our next visual aid, the Sixth Circuit currently has the highest number of cases granted review by SCOTUS for the next term. As with all SCOTUS data, we'll be tracking the cases that they accept for the upcoming October term.
All right, well, that's all the time we have for our webinar today. I don't know about you, but I certainly feel more judicial. To our listeners, feel free to write us at editor@ballotpedia.org and be sure to check out our monthly newsletter, Bold Justice, that covers all SCOTUS related happenings. As you can tell, we sure love talking and learning about the courts.
You betcha. And until next time, thank you so much. And I'm going to gavel out.